Imagine you sign a contract for a piece of equipment, and it just, completely fails to work.
Right, just a total lemon.
Yeah, exactly. But then, a faceless Wall Street bank suddenly demands you pay for it anyway. So, welcome to today's deep dive. We are looking at a legal problem that strikes at the absolute heart of modern commerce.
It really does. It happens all the time.
Right. You sit down, you negotiate with a salesperson, they make all sorts of reassuring verbal promises to get you to agree, and then they slide this dense, pre-printed boilerplate document across the desk for your signature.
And you just sign it because, well, everyone does.
Exactly.
Yeah.
But later, the vocal promise fails to materialize. Under normal circumstances, you just take the product back to the seller. Right?
Yeah, that's the logical step.
But what happens to your rights when the seller has already sold your contract to a third-party debt collector? So, today, we are exploring the intense legal tension between a rigid written installment contract and a side oral agreement.
And that tension is exactly what we are going to dissect today. We will map out the analytical path for you by exploring two heavy-hitting legal concepts. First, we'll examine the doctrine of assignments for what the law calls a chosen action, which is a term of art we need to unpack thoroughly.
Yeah, definitely sounds like a law school word.
Oh, absolutely. Second, we're going to pair that assignment doctrine with a powerful, often invisible legal shield known as a condition precedent. By layering these two concepts, we can see exactly how the courts untangle this whole mess.
Okay, let's start with that terminology, because chosen action sounds like something out of, I don't know, a medieval courtroom.
It kind of is.
Right. For those who deal with modern commercial paper or factoring, we usually just call it buying debt or like assigning receivables. But legally, what is the actual mechanism of a chose in action?
Well, it does originate from old common law. Chose is simply French for thing.
Oh, okay.
Yeah. So a chose in action is a property right in something that you do not physically possess, but you have the legal right to recover it through a lawsuit.
So like a right to sue.
Exactly. If I have a piece of gold in my hand, that's a chosen possession. But if you owe me $10,000, I don't hold that money physically, right? I hold the intangible legal right to demand it from you.
And to sue me if I don't pay up.
Right. That intangible right is the chosen action. And modern commerce relies heavily on the fact that these intangible rights, these debts, can be packaged, sold, and assigned to third parties for immediate cash flow.
That makes total sense. The seller wants cash today, so they sell the right to collect the debtor's money tomorrow. But that brings us to the core friction of this deep dive.
The unmet conditions.
Yeah, exactly. How does the law handle the assignment of these contracts when the original agreement is tethered to an unmet condition? Like, if I owe the seller money, but only if the product actually works, what happens when a debt collector buys that paper?
So the courts rely on a very specific, long-standing standard to resolve this. The general rule, straight from our source material, is this. An assignee of a chosen action acquires, by virtue of his assignment, nothing more than the assignor had, and all equities and defenses which could have been raised by the debtor against the assignor are available to the debtor against the assignee.
Wait, I want to challenge the underlying policy there. Our commercial system relies on the free flow of capital, right?
Sure.
When you buy a physical asset, like a car, you own the car. Why wouldn't the law protect the good faith purchaser of a debt document in the exact same way? If the debt buyer didn't know about the side oral agreement, why are they punished for the original seller's unfulfilled promises?
Because if the law offered absolute unconditional protection to the assignee in these specific scenarios, it would create a massive loophole for fraud.
Oh, I see.
Yeah, think about it. A predatory seller could make wildly false verbal promises to secure a signature, immediately sell the paper to an innocent third party, pocket the cash, and leave the consumer utterly defenseless.
Wow, yeah, that sounds like a scam.
Exactly. The law refuses to let the assignment process act as a laundering mechanism for conditional contracts. The stream cannot rise higher than its source.
That makes sense.
So to apply this general rule rigorously, we explicitly identify its three elements. First, there must be a valid assignment of a chosen action. Second, there must be the existence of a defense, specifically, in our discussion today, a condition precedent against the original assignor.
And the third?
Third, there must be the legal transfer of that defense to the assignee.
Okay, so to really understand how courts untangle this, we need to look at the mechanics of our core source material today. That's Associates Loan Company v. Walker, decided by the Supreme Court of New Mexico in 1966.
Yes, a classic.
This case is the perfect battleground to test this rule.
Yeah.
Let's analyze Associates Loan Company v. Walker. First, What are the legally dispositive facts?
So the Walkers were dairy farmers operating in Roosevelt County. They were solicited by a man named Daniel R. Parton, who was selling mechanical water softeners. Parton's pitch was highly specific to their business. He claimed that installing this water softener for the dairy herd would drastically increase their milk production.
Like generating enough extra profit to easily pay for the machine itself?
Exactly. So the Walkers made an oral agreement with Parton. They agreed to a strict trial basis. They would purchase the water softener IF, and only if their milk production actually increased.
And if it didn't?
If it did not, Parton would remove the machine and the Walkers would owe nothing. After firmly establishing this oral condition, the Walkers signed a standard, pre-printed, all-goods retail installment contract.
But didn't he promise not to sell the contract?
Yes, Parton verbally agreed not to assign or sell this written contract to anyone else. But despite that verbal promise, Parton immediately turned around and assigned the written contract to a third-party financial institution, Associates Loan Company.
Shady. And let me guess, the cows didn't make more milk.
Not a drop more. Ultimately, the water softener failed to increase the herd's milk production at all. The Walkers paid nothing to Associates Loan Company. Parton's business successor eventually removed the device, but Associates Loan Company, holding that legally binding written document, sued the Walkers for the balance.
And what was the core legal issue?
The precise legal question the court had to answer was this. Does an assignee, in this case, Associates, take a written contract subject to an oral condition precedent agreed upon between the jetter, the Walkers, and the assignor, Parton?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The black-letter law applied by the court is that the assignee of a chosen action takes subject to the same conditions as the assignor. This rule breaks down into 3 distinct testable elements.
Okay, lay them out for us.
First, was there an assignment of a chosen action? Second, did the debtor have a valid condition precedent defense against the assignor? Third, does that defense apply to defeat the assignee?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the assignment of the chose in action?
We begin with the first mini-IRS. The sub-issue here is, did an assignment actually occur despite Parton's oral promise not to assign the contract?
Right, because he explicitly said he wouldn't.
Exactly. The sub-rule dictates that a written installment contract for the payment of money is a freely assignable instrument under the law. Even if there is a verbal promise not to sell the paper, the physical transfer of the document with the intent to assign rights is legally effective to move the chose in action.
Oh, wow. So his promise meant nothing for the actual transfer.
Legally, yes. In application, Parton obtained the signed retail installment contract from the Walkers and physically transferred it to Associates Loan Company, assigning his rights to collect payment.
So the conclusion is clear.
Yes. The court concluded that yes, the first element is definitively met. Associates Loan Company is legally recognized as an assignee of a chose in action.
Understood. Now, what about the second element? The existence of a condition precedent against the assignor.
The sub-issue for the second element asks, did the Walkers have a valid defense against the original seller, Parton, based on their conversation?
Okay, and the sub-rule here.
The governing sub-rule here is critical. The law states that an oral agreement stipulating a written contract will not become effective unless a specific contingency happens. Well, that creates a binding condition precedent.
It's like a hurdle that has to be cleared before the contract even breathes its first breath.
That's a great way to put it. When the court applied this to the Walkers, they looked at the specific oral agreement. There would be a valid sale only if milk production increased.
Which it didn't.
Right. The factual record showed that milk production entirely failed to increase. Therefore, the conclusion for this element is yes, the condition precedent failed. Because that trigger event never occurred, the written contract never came into existence as a valid enforceable obligation against Parton.
Wait, so because the extra milk never materialized, the written contract was essentially a ghost? Like it never existed in the first place, despite having their physical signatures on the dotted line.
Legally speaking, yes, it was a ghost.
That's wild. If you're listening to this and thinking about the last time a salesperson promised you a full refund over the phone just to get you to sign a subscription agreement, this is where the Walker case gets genuinely fascinating. The oral conversation actually neutralized the written ink.
It really did.
Understood. Now, what of the third element, the application of this defense against the assignee?
The sub-issue here forms the absolute crux of the dispute. Can the Walkers raise this failed condition against the third-party debt collector, Associates Loan Company, who, was not in the room when the oral promises were made?
Right, they had no idea.
The subrule dictates the reality of the assignee's position. The assignee steps into the exact shoes of the assignor. They acquire nothing more than the assigner had at the precise moment of transfer.
So they get exactly what Parton had.
Correct. In application, the court looked at the asset Associates Loan Company actually purchased. Because the contract was legally dead in Parton's hands due to the failed condition precedent, the lack of extra milk, it arrived completely dead in the hands of Associates Loan Company.
They purchased a legal phantom.
Exactly. The conclusion is yes, the defense absolutely applies against the assignee.
It's like a train being decoupled from its engine. The paper keeps rolling down the tracks into the hands of the debt collector because of momentum, but the actual legal power driving it forward has already been completely severed.
That's a perfect analogy.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the elemental analysis, the Supreme Court of New Mexico affirmed the trial court's decision in favor of the Walkers. Because all three elements were met, the ultimate holding was that the condition precedent defense raised by the Walkers was fully available against the assignee. The written contract was unenforceable, meaning Associates Loan Company gets nothing.
To ensure this rule really sticks in your memory, let's step away from the dairy farm for a second. We need to push this doctrine to its absolute limit to see how durable it is in a much more extreme scenario.
Okay, I'm ready.
I want to present an unforgettable, deeply visceral hypothetical. Imagine you are a large-scale agricultural operator. You hire a specialized, highly aggressive tech contractor to install a massive, experimental biodigester on your property.
It sounds expensive.
Oh, it is. This machine is theoretically designed to process 10,000 pounds of rotting, maggot-infested cow manure every single day.
Wow. Okay. Gross, but go on.
You review a standard written contract that states simply $50,000 due in 30 days. But before you pick up the pen, you look the contractor dead in the eye, and you establish a firm oral condition precedent. You say, listen to me closely. This contract is only valid, and I will only buy this machine if it completely eliminates the vomit-inducing stench of the manure.
Very specific condition.
Right. The contractor smiles, emphatically agrees to the condition, takes your signed paper, and immediately assigns this contract at a discount to a ruthless Wall Street debt collection firm that knows absolutely nothing about farming or biodigesters.
Of course they do.
A week later, you turn the machine on and it completely breaks down. Your farm is now covered in a boiling, putrid sludge, and the smell is apocalyptic. It is a biohazard disaster. But the debt collector's automated system triggers, and they call you up aggressively, demanding their $50,000, pointing strictly to your signature on the paper.
Oof.
So, under our rule, does the farmer have to pay the debt collector?
It is a horrific scenario, but it provides the perfect stress test for the doctrine. Let's analyze your hypothetical systematically using our established elements.
Okay, let's hear it.
First, is there an assignment of a chosen action? Yes. The contractor transferred their right to collect the $50,000 debt to the Wall Street collection firm. Second, is there a condition precedent against the assignor? Yes. The explicitly stated requirement that the machine must eliminate the apocalyptic stench before the contract becomes valid serves as the condition precedent.
Right, they look him dead in the eye.
Exactly. Now we look at the third element, which is where the hammer drops. Does this defense apply to the assignee? The debt collector legally steps directly into the manure-covered boots of the contractor.
Literally, in this case.
Yeah, literally. They acquire nothing more than the contractor had. Because the condition precedent violently failed, the stench was not eliminated, it worsened into a biohazard. The underlying legal obligation to pay that $50,000 never actually materialized.
So the contract was dead on arrival.
Exactly. So the Wall Street debt collector inherits a worthless piece of paper and gets absolutely nothing from the farmer.
But let me push back on the precise phrasing in that hypothetical. What if the farmer hadn't been so definitive? What if the farmer just signed the paper and said, man, I really hope this thing handles the smell. That's the main reason I'm buying it. And the contractor just nodded. Does a vague verbal expectation still operate as a condition precedent that destroys the assignee's claim?
That is a crucial distinction, and the legal answer is no. A vague expectation or a general hope is entirely different from a legally binding condition precedent.
Oh, really?
Yeah. If the farmer merely expressed a desire and the contractor just nodded, the court would likely view that as a collateral warranty or a general representation, not a condition precedent.
So the wording really matters.
It's everything. A condition precedent specifically requires that the parties agree the contract will not come into existence unless the event occurs. The difference is existential.
So if it's just a breached warranty, the contract is still technically valid, right?
Right. If it's a breached warranty, meaning the contract is valid, but the machine is defective, the debt collector might actually have a much stronger case to demand payment under the written terms, leaving the farmer to separately sue the original contractor for the defect.
Wow.
The magic of the Walker case and your biodigester hypothetical hinges on the fact that the oral agreement explicitly conditioned the very existence of the contract on the outcome.
That is an incredibly fine line, but it makes perfect sense. The defense isn't just the product was bad. The defense is we explicitly agreed this document wouldn't be a contract unless the product was good.
Exactly.
That is incredibly empowering knowledge to have as a consumer or a business owner. But spotting these issues in the wild or, if you're sitting for a law exam can be incredibly tricky. The assignment usually happens silently in the background.
You never see it coming.
Right. You only find out a third party is involved when the demand letter suddenly shows up in your mailbox. So I want you to synthesize this entire analysis from today's deep dive into a practical, step-by-step diagnostic checklist. Something you can use for exam taking or issue spotting in the real world when dealing with assigned debts.
Absolutely. This is the definitive exam framework synthesis for handling assignments and conditions precedent. When you are faced with a fact pattern involving a sold debt, do not get overwhelmed by the paperwork. Just follow these 4 analytical steps sequentially.
Okay?
Step 1, identify the underlying contract and the original parties. Do not look at the debt collector yet. Pinpoint exactly who the assignor is, the person originally selling the goods or services, and who the debtor is. Understand the core transaction first.
Step 2.
Step 2, spot the assignment. Identify the assignee holding the paper. Look for the exact moment the original seller transfers their right to collect payment to a third party. Acknowledge that a chosen action has moved.
Okay, got it. Step 3.
Step 3. Interrogate the original transaction for any unfulfilled conditions, precedent, or equitable defenses. This is the most crucial step of the entire analysis. Ask yourself, was there a side agreement? Was there a specific verbal promise that served as a trigger for the contract's validity?
Right. Did the event triggering the contract actually happen?
Exactly. If the condition failed, establish that the defense exists against the original seller.
And finally, step 4.
Step 4, apply the shield. Transfer the defense to the assignee. Remember the governing maxim. The assignee acquires nothing more than the assigner had.
So if the contract was a ghost?
If the contract was essentially a ghost and unenforceable by the original seller, it is a ghost and unenforceable by the new debt collector. Walk through those 4 steps methodically, and you will perfectly structure your legal analysis of assignments every single time.
Step 3 is really where the heavy lifting happens, isn't it? Interrogating the original transaction. It requires you to look past the intimidating, legally dense boilerplate and remember what was actually said in the room between the human beings making the deal.
It's all about what was actually said.
Which brings us back to where we started. The assumed permanence of the written word versus the messy reality of the actual deal. I will leave you with a final thought to mull over as you go about your week.
Go for it.
Think about the boilerplate agreements you sign every single day. Think about the gym memberships you authorize, the auto loans you take out, the appliance purchases you finance. Now think about the enthusiastic verbal promises salespeople make to you just to get you to sign on the dotted line.
You can cancel anytime, no questions asked.
Exactly. Or, if it doesn't boost your Wi-Fi signal to the garage, we'll tear up the contract. If your debt is bundled up and sold to a faceless corporation tomorrow, would those verbal conditions precedent be documented well enough to protect you in court today? Or would it just be your memory against a signed piece of paper?
That's a scary thought.
We like to think that when we sign a contract, it is carved in stone. But maybe the real power dynamic of modern debt assignment isn't about what is written in the stone. It's about who holds the hammer when those verbal promises turn to dust. Keep questioning the assumptions behind those contracts, and we will see you on the next deep dive.